Case People versus Mershon Smith.
Our assistant prosecuting attorney for the people.
This case starts with a simple request, a bond reduction. But within minutes, the courtroom hears allegations of ignored court orders, a no-contact violation, and a defendant running from police through the snow. Daniel Smith says he's about to lose his job, his home, and his family's stability. Prosecutors say he showed exactly why he shouldn't be trusted. Now the judge must decide, is this a man who deserves another chance, or someone who already proved he won't follow the rules?
Brian Bowling on behalf of Mr. Smith, Your Honor. And Mark, state your name for the record, please.
Marshall Smith.
Thank you.
Judge, we're asking this matter be set for a preliminary examination.
Discovery is complete.
I believe it is, yes.
People, other witnesses available the 13th.
Yes, Your Honor.
Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Bond will continue.
Your Honor, may I address bond?
You may.
Your Honor, this is the only matter holding Mr. Smith to my knowledge. There's a $25,000 bond. He indicates to me that he is employed at Toyota in Saline, which is a very good job. He believes he will lose that job if he remains in custody any longer. Further, it's come to his knowledge that the apartment that his fiance and daughter live in Ypsilanti, that they are going to be evicted from that residence if he's not able to be the financial support for those individuals, which ultimately ties to my early argument regarding his job. He indicates to me
the
that
apartment in his name.
It is. Your
yes.
Honor.
Who's the landlord?
We just moved there. We moved out of Arbor One into this apartment.
What's the name of the apartment complex?
I can't remember.
You just moved out of Arbor One. How long ago?
Like 60 days. We moved out of Arbor One into this apartment. We've been trying
Because you were
because it was
a mess
condemned.
over there.
Yeah, it was condemned. And we just got this apartment, Your Honor. I don't want to lose it.
Your Honor, just
Okay, have they started? It's in your name?
The apartment is in me and her name, yes.
We don't have anything in his name.
I could try to come up with the lease or something, but if my name is on the lease with her.
You know, when you're winning, you should stop talking.
Sorry.
See, the way he reacted, thank you, sir. If attorneys would react that way, my day would be so much easier. Anything from the people?
Yes, Your Honor. Your Honor, the facts of this case, Mr. Smith was released on a DV case. It's a city prosecution out of Ypsilanti. Several hours thereafter, the police were called because he had contacted the victim's grandmother. The victim's grandmother called the police, indicated that he had told her that he was on his way over and did not care what happened. There was a no contact and a stay away order in place on the domestic violence bond. When he arrived, police had already gotten there. He was observed by the arresting officer standing outside the door. The officer asked him to stop and come and speak to him. He immediately ran. The officer had to chase him out of the building, down the street, through the snow, until eventually he fell down. The officer tased him. He did not stop. Eventually, he was able to take him into custody. The people are very concerned about his refusal to follow the court's orders regarding bond, as well as his refusal to follow the orders of law enforcement.
may I respond to that? Your Honor, it's my understanding that Mr. Smith, regardless of any other calls that may have been made, was he reached out to the Ypsilanti Police Department for a civil standby or civil assist visit at that residence to obtain some items. It's my understanding he was in communication with the Ypsilanti Police Department, actually received a return call from them, telling him to go to that location. I mean, ultimately, we're here for the allegations that Mr. Overwater just stated happened once he came in contact with the police at that location. But
what happened to the underlying DB?
It's still pending. There is a personal bond on that case. I believe it was scheduled for a hearing yesterday, and nothing was changed.
So that's what I'm trying to figure out. So if the violation is for the underlying DV, he goes there, which would be a violation on that case. And where you would suspect that his bond would be denied.
Fair enough, but
his bond is not denied. He has a PR on that case. And because, all right.
And I mean, I'm not sure exactly what happened with respect to the
What did I
call.
tell your client?
Yeah, fair enough.
Okay. I understand the circumstances, but if there's really a safety issue with this individual and not being able to follow the orders, that needs to be taken care of in that other case. I don't, if I'm looking at this case, I think his bond is inappropriately set. I'm also, because of his Arbor One situation, I'm a little bit worried if he loses that apartment, he's probably sat in a condemned unit for a number of months, just trying to find a way out. So what I will do is I'm going to grant the motion for a bond reduction. His bond in this case will be reduced $25,000 personal recognizance bond.
Thank you. Thank you, Your Honor.
And thank you.
You're welcome, sir.
Thanks, Justin.
All right. Don't make me regret it. Do the right thing. You hear me?
You won't, Your Honor.
Take care of yourself. Court calls the case People versus McKell. Is it Urquiza?
I believe it is Urquiza, Your Honor.
And then on behalf of people.
Assistant Public Defender Davia Leba on behalf of Mr. Urquiza. And Your Honor, Mr. Urquiza would like to waive his preliminary examination. And if you'd like
Your name, sir?
Miguel Urquiza.
And Your Honor would like to address bond as well.
Of course you would. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yeah.
You understand you will not have that hearing, you'll proceed to circuit court for further resolution.
Can you give me a second? Yes. Oh.
Oh. How many more of those?
Sure, if you think about it more, we can do that. I think it's a good decision, but it has to be. We'd ask for it. We're trying to. Yeah.
Okay.
Yes, understand.
All right. You understand you will not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination, having the way defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, and we acknowledge receipt of the we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having way formal reading standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for January 13th, 2026, 1:30 before Judge Conkey. As to bond.
And with regard to bond, I think the past couple weeks in jail have taught Mr. Urquiza a very significant lesson, both about the seriousness of this case and about the importance of following this court's orders regarding bond. He is 20 years old. He is a college student at the University of Michigan. He has a supportive family. I believe both his parents are present in the courtroom today. He's told me he is actually doing very well in school. It's a 3.5 GPA, and he's currently scheduled to go back to school on the 7th. He's also told me that he was accepted recently to him.
Why did he lie to me when he came before me?
Mr. Urquiza, would you perhaps like to address the court on that?
Like regarding to the Adderall?
Yeah.
Well, yeah, I did. Well, a family member did take it, and I made the, like a careless decision of taking it. I knew it was going to bring me consequences. I didn't think about the consequences before doing it, and which now, like,
Well,
I know.
once you got caught,
So I guess what I don't get is once you got caught, why'd you lie to me? I mean, I look stupid, but I'm really not.
No, I'm not trying to say that, Judge, but you know, after just
Okay, why'd you lie? Oh, that's a hard question.
Just say you took it. You were scared. Just say that.
I was well, the reason why I lied was I was scared. I just didn't know the consequences that would be following it.
Really?
And well, that was
So how'd that work out?
it didn't work out really good.
It
It was
really didn't.
my fault. So, but after spending, almost 2 weeks, in jail, I learned that freedom is like a privilege that many others take for granted. And, after learning that, if given, a chance, I won't take that for granted.
You came up here, it's really funny, because you came up here really smug and everything, just doing what you were doing. And I asked you a simple question. You just lied to me, tried to smile at me like whatever it was. And you didn't seem to get it. I don't play that.
I understand.
So I don't know if you do. Lucinda?
Your Honor, at this point, I would object. I think maybe a release to inpatient might be appropriate at some point, based on the mistest, the THC, the Adderall, and then if he was intoxicated as a part of the underlying charges. So I think there are some issues that need to be figured out before he's just released back in the community.
Your Honor, I have no objection to him being released basically on home confinement with an instruction to immediately get a substance use assessment. But as of now, I don't think there's any reason to believe that he's in need of inpatient treatment.
Okay, let's look at this. How am I going to keep him away from the drugs?
Your Honor, I think the past 2 weeks have taught him that he cannot even think about touching substances. I think that's very clear to him now.
So he should have learned a number of lessons. Don't touch that. Don't lie to me.
I think this is probably the biggest learning experience of Mr. Akiza's life, Your Honor.
Really?
Would you agree with that,
That's
Mr.
a lot of
Akiza?
money to
Yes.
pay for the U of M. This becomes your biggest learning experience. Where are you from?
I'm from Chicago, Judge.
Oh, he's trying to roll some Chicago stuff on me. That didn't work, did it?
I'm sorry?
That didn't work, what you were trying to do. Why didn't you just come in and tell the truth?
Well, I was scared. Well, I've never been in this type of situation before in my life. I've never been in trouble. I've never been in the state.
Why didn't you just tell me the truth? Did you think lying was going to get you anywhere?
No.
I mean, that's the other part. Did you think it was really going to get you anywhere?
No.
Why did I have all these missed tests? Because that's the other thing.
Your Honor,
I this one test, but it's positive THC.
Right. I'm sorry. I meant to phrase it differently. You don't have a medical marijuana card.
I don't. But after my release, I don't know why I showed up positive and negative.
You don't know why?
No, I didn't. After my release from Washington, I didn't take any edibles or I didn't consume any THC. I obviously knew and learned not to.
So how did it get into your system? You're an amoeba. It just absorbed into your system? Why do I get the feeling you're not telling me the truth?
Your Honor, Mr. Akiza has indicated to me pretty much since this violation of THC came to light that he does not believe he's used THC since.
So this THC, how did it get into his system?
That I don't know, Your Honor, but
Really? You don't know? You weren't there with him?
I was not, Your Honor.
Okay, so he knows.
I believe.
I don't know. No, you know what, young man? Here's what we're gonna do. And I hate holding everybody up, particularly the jail. They've been great today getting these people out. I've got some others that are in custody that have to come out. I'm going to send you back. I'm going to do you the favor of recalling your case at some point when you have a chance to speak with your attorney and decide you're going to tell me the truth. I'm not stupid. Don't say anything because otherwise my decision is going to be you're going to sit. Take it back.
After hearing everything, the judge makes it clear, second chances come with consequences. This courtroom isn't about excuses. It's about accountability, honesty, and following orders. If you want real courtroom moments, real decisions, and real consequences, make sure you like, share, and subscribe. More courtroom footage coming next.